Welcome. My name is Chris Templeton, and I'll be your moderator for the next hour. You're in for a real treat. This is a rare opportunity for EEO investigators to see what happens after an investigative report is submitted and to get important feedback directly from the consumers of your work, the judges. So welcome everybody. A few quick ground rules. Number one, please feel free to ask any questions that you have via the Q&A button, which you can see at the bottom of your screen. The one rule that we have is you cannot ask case-specific questions. And what I'll be doing is reading those questions. It's too important for me to try and pretend to look at the screen the whole time and not get these questions right. So that's why I'll be reading them. And I just want to thank you all for being here. Next, what I'd like to do is introduce our judges for today. First is D. Andrew Winston, who has been an administrative judge with the Denver field office of the Equal Employment Opportunity Commission since 2015. Judge Winston first joined the EEOC in 2007 and served as a senior trial attorney with the Denver field office legal unit. Prior to joining the EEOC, Judge Winston was in private practice, focusing on labor, employment, civil rights, and entertainment law. Our next judge is Jacob Smiles, and he's an administrative judge with the Denver field office of the U.S. Equal Employment Opportunity Commission. As an administrative judge, he presides over federal sector employment discrimination complaints. Prior to becoming an administrative judge during the summer of 2015, he worked for 5 years as an attorney for the U.S. Department of Education's Office of Civil Rights in Denver, Colorado. Our third judge is Nancy Weeks, who's been at the EEOC for 29 years, and prior to that worked for the defendants and employers. Prior to becoming an administrative judge, Nancy worked for the EEOC and served as a senior trial attorney with the Denver field office legal unit. Welcome to all of you. What I want you to know is that I will be addressing them casually as they have agreed to take off their wigs and let me call them Andy, Jake, and Nancy. So I want you to know up front that's how we're going to proceed with this. So to get a better feel for who the judges are, I want to introduce you and by asking each of you the following question. Judges, why is this work important to you? And let's begin with Andy, and thank you for being here.
And I'll answer for Andy. This is Jake. Andy has just lost his internet connection. He is trying to rejoin and will be on in a minute. So perhaps I'll begin.
Thank you. That's great.
Okay, sure. So why it's important. You know, obviously our country has a long history with discrimination. And when you think of the employment aspect of it, employment is among the most important things in any individual's life. You know, there's family. Other people have a few other things, whether it's religion or other aspects of their personal life. But beyond that, for many people, their job is how they identify themselves. It's where they get their self-esteem. And it's incredibly important. And when that gets disturbed, whether it's through discrimination or any other means, it can have a traumatic effect on a person. And so I just think, yeah, to the extent we can eliminate and prevent and educate people about employment discrimination, I think it can have a profound impact on the individuals, their self-worth, and their ability to provide for their families.
I think that's an outstanding answer, and thank you very much for getting in there quickly, Jake. Nancy, how about you?
Hi. Well, I've always had an interest in supporting the underdogs. And maybe that's partly because I'm a woman in the field of law, and I graduated over 30 years ago, so there were a lot less women then. And also in 2007, I adopted a child who happens to be African American, and I think that brought me from the intellectual understanding of discrimination to a much more heartfelt one. Because, for example, we went to spring training in Arizona, and I was carrying her, she was 2 years old, and people were giving us like really dirty looks. And I suddenly realized, wow, this is way deeper than I ever imagined. And so that sort of informed my practice since then.
Wow, thank you very much. I'm assuming we don't have Andy back yet. So let's move on and talk a little bit about the EEO process. Many or most investigators do not have visibility into the EEO process after an investigative report is submitted. Could you both give us a view of what happens after a case is appealed and gets assigned to you? Nancy, do you want to start?
Sure. One thing that maybe the investigators don't know, but a lot of EEOC offices have a big backlog. So until recently, if an individual requested a hearing, they would wait up to a year before it got assigned to one of us judges. And then after that, it's like a little mini court process where we have an initial meeting, the parties generally engage in discovery, try to get more information. There's a possibility for summary judgment, settlement, and then ultimately a very small number of cases actually go to hearing.
Jake, would you like to answer the question of what happens after the case is appealed?
Sure. And so, I think it's interesting too at the beginning to point out, just as often the EEO investigators don't quite know what happens after they complete their investigative summaries. I was realizing this morning that the AJs have no idea what's going on your end in terms of what pressures you get from the agencies, what resources you have to complete the investigations, how much cooperation you get. And so, I think the lack of knowing what goes on goes both ways. In terms of what happens after the investigative report is completed, so many of the cases, they receive what's called the final agency decision. And we have no involvement with that. But when someone does request a hearing, like Nancy said, it sits in a docket for a while and is finally assigned to an administrative judge. And after that, it's very similar to what you would have in federal court, except that it's far less formal. Often the parties are pro se. I think we probably are more flexible with deadlines and rules of evidence and that sort of thing. But otherwise, it's like litigation in federal court, except that we have this evidentiary background, the investigative reports that you all complete that are extremely useful in getting started in this process.
Thank you. Andy, would you tell us two things? We'll go back to talking a little bit about why this work is important to you, and then from your perspective, help people to understand what happens after a case is appealed. And thanks for being here.
Sure. I had a little bit of a technical glitch, but I got it figured out. I think what makes this work pretty critical, and I think most complainants would agree, because most of them are, I would say better than 50% of the cases I have, the complainants are pro se, they represent themselves. So it's an access to justice kind of issue. The process is set up where you don't necessarily need a lawyer or a representative to work your way through the process, although that's certainly your right. And I would advise it because it's an adversarial legal process. It is a little Byzantine, but it's a fairly quick process. It's a fairly economical process. Whereas if somebody only had access to federal court, that's an expensive proposition and much tougher to represent yourself in federal court. So for a lot of federal employees, this is really their only access to some kind of system to get a review of the situation that's occurred. So I think that's, in my mind, the most important thing that makes this work so important. In terms of what happens after a complaint is filed and what that process looks like, I mean, the nuts and bolts is, as Jacob and Nancy described, an investigation, which you all do, is completed. It's the ROI, or the deliverable, the report of investigation, is given to the complainant and the agency, and then the complainant has a choice to make. Do I want a final agency decision, a written decision by the agency that this is what happened in the case? Or do I want a live hearing in front of an administrative judge? And many complainants choose the live hearing. And many of the pro se or self-represented complainants don't really know or appreciate what that means, that they're actually going to have to put on a live case with witnesses and exhibits. And they've seen a lot of TV, but it's a little different when you're doing it yourself. So a lot of times when we get into the process, we have what's called the initial conference typically first, which is a conference, it's usually over the telephone, and we talk about the case and what the claims are, and we set the deadlines for discovery, and then a self-represented complainant's like, oh, this seems really kind of daunting. Can I do this? And some folks drop out at that point or seek mediation. And some continue, some get representation, although, as I said, I think in my experience, probably more than half go on and represent themselves. And they get the deadlines for discovery, they start doing discovery. Many of them don't even know what that is. They may have heard of an interrogatory or a deposition, but they're not really familiar with how to do those. Pro se complainants frequently have more questions. And I invite them to ask me those, although I have to maintain neutrality. I can kind of give them some guidance on procedural things, but I can't give them legal advice. And that, you know, I have to preserve my independence and my impartiality. The thing I have to remind them the most about is, and I have to do this in a gentle, tactful way, I'm not their pen pal. They tend to want to email a lot and communicate with you, and they often, a lot actually, forget to include agency counsel on those communications. I have to gently and kindly remind them, we can talk about procedural stuff, but you have to make sure agency counsel is there and part of that conversation. And then, you know, if they survive summary judgment phase, the summary judgment motions are a motion typically filed by agencies after the close of discovery, trying to get the case dismissed. If they survive that, then they're heading towards a hearing. And if there hasn't been a settlement conference by that point, usually there has been at least one, but if there hasn't been a settlement conference, I almost always insist that there be one between summary judgment and hearing to give the parties an opportunity to try to resolve the situation themselves. I always tell them, you know, I'm hired to make these kinds of decisions, but you don't necessarily want me making them. It's better if you all resolve the situation yourself and create the future you want, as opposed to having a neutral third party impose a decision on you. You're not going to like that very much. One party is going to be unhappy and will likely appeal to the next level up, which is the Office of Federal Operations, or OFO. So that's a quick down and dirty overlook of the process.
Outstanding. Thank you. Thank you. So as judges, describe the importance of the investigative report. Talk a little bit about what happens with one's poorly done versus one that's well conducted. How about Nancy?
Okay, the investigative report's really important because other than like the charge, that's how we know what's going on in the case. And a lot of times the charges are pretty minimal. And so the investigative report lets us know, like, who are the parties, who did what's really going on here. Not in a legal manner necessarily, but like sometimes you see, okay, these people don't like each other very much. And is that discrimination, or is that, you know, just people not liking each other? If an investigation is poorly done, sometimes the AJ will order the agency to produce, for example, if you have someone asked this in a later question, I think, but if you have a non-selection and you don't have any information in the investigative report about who were the applicants, who was the selectee, what are the documents, you know, who were the people who made the decision, the AJ can order the agency to produce all that information. And then that'll give us a little further to go. Similarly, if you don't get to the heart of what's going on, for example, a lot of people do interrogatories written. And so a lot of, especially people who are accused of discrimination, kind of skirt the issue or don't answer fully. And that makes it hard, because essentially what's going to happen is then in the discovery phase, a complainant who doesn't necessarily know what they're doing is going to have to try to get that information, where if it had been done fully in the investigative file, a lot of times it's easier for us to just say, okay, we see both parties have risks, let's talk about settlement. So that's sort of a summary of some of my issues.
Jake, what about you?
Sorry, I was having trouble getting off mute there. So yeah, I don't want to repeat too much of what Nancy said, but other than just to reiterate, it is incredibly important. It is the foundation of the case. And I should clarify, so when some of these terms get used interchangeably, and when I think of the investigative report or the ROI, sometimes it's called, I think of the entire investigation. Then there's also the investigative summary, which is the investigator's summary of the investigative report. So with respect to the entire investigation, like I said, it's the foundation of the case. Many of these complainants are pro se, representing themselves, and will not do any discovery. And if the investigative report is not thorough, if there aren't follow-up questions in the witness interviews, they're not going to have much of a chance. The evidence just won't be in the record until, eventually at the hearing, if the administrative judge needs to ask questions. But the reality in this process is very few cases actually go to hearing. And so many of them are decided on summary judgment. And so, the investigative report is very important for the complainants to have, the evidence they need to survive summary judgment. Many of the cases that have a strong merit are resolved through significant settlements. And again, the agency attorneys will review the investigative report, and when it's thorough and documents, mistakes made by the agencies, that's really strong support for the attorneys to go to their client and say, we really need to settle this case and not go to hearing. And so the hearing process allows us, to examine witnesses and get extra information. But, like I said, many of the cases don't get that far. And so whether it's summary judgment, settlement, whatever else it might be, the investigative report is really critical, especially for those complainants who don't have an attorney to do depositions and supplement the record through discovery.
One of the questions that's come up is, are summary judgments like the accept dismiss phase?
And is that for me?
Sure.
Okay, sure. It's a different legal standard, but to some extent, yes and no. It's a gateway. If summary judgment is granted, that's the end of the case. There is no hearing, and it's closed, and that's the end of it. If summary judgment is denied, what I always tell pro se parties, the motion for summary judgment, and it is filed in almost every single case, is sort of the last hurdle before a case gets to hearing. And so once they survive that motion for summary judgment, then we set a date for the hearing. And so, yeah, it is very similar to the dismissal, that the EEO investigator or the EEO office analyzes at the beginning of the case. It's just a different legal standard.
Excellent. Andy, would you talk a little bit about the importance of the investigative report from your standpoint? And would you also just focus a little bit on when you have one that's not well done?
Sure. I would echo what Nancy said earlier about the report of investigation, that in terms of approach, first of all, it's absolutely critical. I mean, and when we get a case assigned to us, it's our first glimpse into the case. And one of the first things I do is I look at the investigator's summary of the investigation. That's my first blush at the case and the issues that are before me. Then obviously, after reading through that, you were able to zero in pretty quickly who are the important witnesses and what are the important documents. And then you dive in a little bit deeper. You start looking at the exhibits and the attachments. I always review the complainant's affidavit or declaration, and certainly the key responding management official or RMO. I always look at his or her or their affidavits, because obviously everybody's going to have a different view or version on what happened. And I look at the key documents, and that gets me an entree into the case and prepares me to discuss it with the parties at the initial conference. The better investigations are the investigations that rather than send written interrogatories or questions to the parties and get their answers, which tend to be incomplete, tend to be vague, tend to be ambiguous, the better investigations have a live interview associated with them in some way, whether it's a fact finding or whether it's, you know, almost a deposition that the investigator takes, but certainly at the very least, that the investigator interviews the individual by telephone, and when the individual says something that's a little slippery and not answering the question or being kind of vague or cute or ambiguous, the investigator can follow up and say, well, what do you mean by that? You know, how many times did this occur? If it's a harassment allegation, you know, and say racial comments were made, well, how often did this happen? Were there any witnesses? That kind of thing. And you often can't get that kind of granular detail if you just are using interrogatories. So the better investigations there's a direct interview involved. And I mean, there's different ways to do that. But the written interrogatory approach usually leaves something to be desired. And to me, anyway, the better ROIs have a live interview. The best ROIs have everything you need. I mean, obviously the standard for the investigation is that it provides enough information for a neutral fact finder to be able to draw a conclusion. Now, the investigator's not supposed to draw a conclusion, and the investigator's not supposed to be the friend of the complainant or the friend of the agency. The investigator's trying to develop all the information and be as exhaustive as they can, obviously within reason. If the complainant gives you a list of 13 people and none of those directly witnessed the events and have no first person or firsthand knowledge, everything they know was told to them by the complainant, then there's no need to interview those people because they're basically going to be testifying from hearsay. But there's no such thing as too much information, relevant information. So that would be my take on what the best ROIs look like.
And how about this for a follow-up? One of the questions that just came in is, how do you decide a case where there's no evidence that supports a side and just one word against another?
So that's what we call credibility determinations need to be made. And that comes in when we look at the summary judgment process. So the summary judgment standard, and as Jacob mentioned, summary judgment's a huge motion that's made after the close of discovery and before the hearing, almost always filed by the agencies. On occasion, I've seen complainants file them, but that's very rare. And basically what the agency or what the movant, the person filing the motion, is arguing is that even if you assume everything the other side says is true, they can't win, and here's why. That's kind of a quick view of the standard. You're looking for whether or not there's a genuine dispute as to any material fact. And a material fact is a fact that it will make a difference into the determination whether or not discrimination has occurred. So if you've got a he said, she said, or a she said, she said, or a he said, or a they said kind of question, then that's a credibility determination. And if one party's versions of events versus the others is completely black and white and different, then I can't grant summary judgment. If there's a dispute on material facts, if it's peripheral stuff, maybe I can decide it. But if it's a key or core fact or facts that are going to make a difference in the determination about whether or not there's discrimination, then I have a credibility determination to make. And you can't, I mean, there's all sorts of case law that says you can't make credibility determinations at the summary judgment phase. Basically what that means is complainant survives summary judgment and he or she or they get to have a hearing. So then what I do is I'm going to have a hearing and I'm going to observe the testimony, let it kind of wash over me and absorb it, watch the demeanor of the people who testify and try to decide more likely than not what happened and decide who I think is more likely telling the truth and whose version of the facts more likely reflects what really happened. So if there's a he said, she said situation, it's going to go to hearing.
Jake or Nancy, anything that you want to add to that?
Hi, this is Nancy. One thing I will add is that I noticed a lot of times people tend to misuse evidence. So they'll say, well, the complainant has no evidence. And I look at the file and the complainant said, this happened, I was there, it happened to me, you know, here's what happened. That's evidence. Now, they might not be able to support that with external stuff that would help one believe that. But if the complainant says he discriminated against me, that's a conclusion. So it's good to make that distinction, because sometimes complainants, when you say, do you have any evidence? They say no. And then if you continue to question them, they'll say, well, I noticed that this manager hangs out with the men and he gives the men better assignments and those kind of things. Those are evidence. You may not be able to corroborate them. They might not be enough for the person to state a claim, but that's the kind of evidence that, and so I always ask people not to use the word evidence. Like, what did you see? What did you hear? And why do you, ask the complainant, why do you think this is discrimination? And sometimes they're just like, well, because I'm the only Black person in the group. Well, okay, that's one bit. You need some more bits, but the why question I don't think should be avoided, because a lot of times it goes to the heart, and it allows, when it gets to us, for us to realize how we can settle things.
Thank you. Jake, anything you want to add?
Yeah, I'll just add quickly to what Andy had said. Just because there is a he said, she said dispute about fact, that the materiality question really is the key. If the dispute is, well, an employee is saying my supervisor was calling me racial epithets or the N-word or, horrible things, and the supervisor says, no, I didn't, we need to have a hearing to resolve that. If the, he said, she said is the supervisor was giving me dirty looks, and, I just felt he didn't like me, more minor things, and the supervisor says, I never gave that person dirty looks. Well, that's a dispute, but it's not material. It's, even if true, even if the supervisor maybe had an angry face one time or a few times, that's not going to be severe or pervasive. And there is a dispute of fact, but it's not material, and we would still grant summary judgment. So there's both the disputed fact and the materiality question. And I think just need to remember both of those.
One of the questions that just came up is, the trend in my case is that management requests IROGs, and some complainants and the procedures allow them. Do you have any advice on how to make the IROGs better or as beneficial as possible?
This is Andy. I'll jump in on that. The investigator decides how best to investigate the case, not the agency. So if the investigator decides, I want live interviews, you get live interviews. It's not for the, and similarly, it's not the complainant to decide how the investigation is to be conducted. For instance, the example I gave earlier of 13 witnesses that the complainant wants the investigator to interview, but none of whom have any personal firsthand information. The investigator gets to decide, do I need to interview those people? And if the fact that the agency prefers or wants to handle statements through written questions, the concern I would have as an investigator, and I did investigations once in a previous life, and what concern I would have about those as a neutral decision maker, a fact finder, is that it's easier for the agency and agency counsel to control what the responses are in written interrogatories. So that's why they want to do that, is they're trying to be very careful and manage the responses that end up in the written record. So you, as the investigators, you have the right to decide how best to conduct the investigation. That's your power, that's your authority. And you should feel free to use that in your best judgment and your experience.
Nancy, anything you want to add to that?
Yes, I would say, from teaching some refresher investigator classes, this has come up, and it is hard, because obviously a lot of times it's your supervisor telling you this is how we're going to do it. And so I would say, kind of raise like I'm supposed to be independent and all, but also you can use us and say, we were at this training and the AJ said this is how it's supposed to be done. Because obviously there's a tension between a neutral investigation and the fact that the agency is investigating itself. And I think if all of us judges created a system, it wouldn't be that way, but that's how the system is. So be strong and try to, make your case, and then you have to decide, how to live with yourself with the investigations you have to do.
talk to us a little bit about moving on. What happens during the hearing process? Nancy, you've got the floor.
Okay, so in the hearing process, once we get past the summary judgment that we've talked about, and we say, okay, we're going to hearing, and we all do all of our hearings now in a Zoom or WebEx or something. What happens is the complainant's got the burden of proof. So the complainant's got to be able to show evidence that more likely than not, and that's the standard, it's not, you know, beyond a reasonable doubt or anything, more likely than not, these events happened because of discrimination. So the complainant usually goes forward, presents their witnesses. Both parties get to cross-examine the witnesses. So that, for example, if there's two lawyers, they'll test the credibility by saying things like, well, didn't you say in your affidavit XYZ, and now you're saying ABC, and those type of things. We try not to be too repetitive because we do have the investigative file, but also at least I give the lawyers or the complainant leeway because they're trying to tell a story. And sometimes the story is different or comes out different than, you know, the separate investigations. So then after everybody puts on all their witnesses, we close the hearing, and then we, AJs, issue a decision. And then it goes back to the agency. So our decision is final for us, but goes and the agency can adopt or reject our decision. And then there's an appeal process to the Office of Federal Operations if either party doesn't like that decision. So that's one thing I think investigators should know is it's a lengthy process. Because let's say it's a year, however long you took, a year to get it applied, assigned to us, and then a year or more in front of us and appeal. And so I always remind both parties, but especially complainants, because they don't know, do you want to be dealing with this in 5 years or do you want to resolve it? Because generally it's more healthy to resolve it as soon as you can.
Thank you. Andy, do you want to add on anything there?
Going back to what I mentioned before about over half of my complainants are pro se. I've had a number of hearings this year where the complainant represented themselves. And as I said, it's kind of a daunting process if you're not an attorney or if you haven't done this kind of thing before. So obviously they've seen a lot of television, but they don't necessarily know how to ask a question or get an exhibit into evidence. So I give them little helpful nudges along the way. Now, the other thing I might do as a hearing judge is I know what the elements of the claim are, obviously. I know what needs to be proven in order to make sure that the complainant has an opportunity to put on the evidence, the testimony and exhibits that they need to prove their claim. So, and I always have the elements handy nearby while the hearing's going on. And as the evidence and testimony is coming in, I'm glancing and checking at the elements to make sure, okay, well, they checked that box, they got that, they proved that they have a protected class, say that they fall under the discrimination statutes. And if in the course of their testimony, they aren't getting to a critical element, I'll step in and ask a question to make sure whether or not there is any evidence to support that element of their claim. Because say there's 4 elements to a claim, if they miss one, they lose. They haven't made a prima facie case at that point. They don't even get to the point where the agency is obligated to put forth its legitimate non-discriminatory reasons for what it did. But if the complainant does make the prima facie case, then the agency has to explain the reasons why they did what they did in any given situation. And then the complainant has to show evidence of pretext. So, and if, I mean, these are all legal structures and legal standards, and it's tough for a layperson, a complainant, to know that and be able to step in and function in that capacity on their own behalf. Typically, pro se complainants think everything's important. Not everything's important. What you need to show are the facts which support the elements of the claim that you're bringing. And they may or may not know that. There are points in the process where I try to emphasize to them that there are elements they need to be conscious of and be prepared to present evidence on that. For instance, in the initial conference, the first get together with both parties, one of the things I do is if I have a pro se complainant, I insert a section in my order that I issue after the initial conference, which lays out the elements that they're going to be expected to prove. And throughout the hearing process, in discovery, in summary judgment, in the pre-hearing conference that we hold before we have a hearing, I point back to that and I remind the complainant, now take a look at the order that I issued on such and such a date, and you'll see the elements of the claims that you need to show. So when you're putting together your presentation, be thinking about those, because that's what you need to prove in order to convince me that that discrimination more likely than not occurred.
Can I just add one thing? Oh, and Chris, I think you're on mute still. And I saw you speaking.
Yeah, go ahead.
Oh, just one thing about the importance of the investigation as it relates to the hearing process, since we're talking about hearing testimony. It's definitely a frustration, for me, the delay that we have in getting these cases to hearing, but it is the reality. I had a hearing last week that was from 2015, the allegations. We've gotten much better about it, so it isn't taking as long to get these cases to hearing, but many of these cases are 3, 4, 5 years old. And so the witnesses are not necessarily lying, they just can't remember things that happened 3 to 5 years ago. And so very often, we go back to the interviews in the investigative report and their affidavits. And so they'll say, I really can't remember that. And then we can show them a document that, 5 years ago, you wrote X, Y, and Z. And they'll say, oh, you're right, that is what happened. And so, often we have the witnesses before us at the hearing, but the best evidence really is those affidavits from the investigative report that were taken so much closer in time to the actual incidents at issue.
Thank you. Okay, let's move on to the investigative file and how to create high quality reports. And what we're going to do is we're going to talk about a number of different areas. And where we're going to start is in a harassment case where non-discrete actions are alleged, how much detail do you need in a report of investigation? Go ahead with that. Why don't you, Jake?
And I guess, do you mean in the accepted allegations or in the actual investigation and the affidavits and interviews?
I'm going to let you pick whichever one or both of you want to talk about.
So in the interviews, I think it is important to address all of the allegations of harassment. If it's dirty looks here and there, you don't need to get to every single one. But in general, when a complainant identifies, a number of incidents, whether it's 10 to 15 different things that happened over the course of the year, I think it's worth addressing all of those with the people who actually witnessed those incidents. And that is critical to the investigation and understanding what really happened. I don't have a better answer about what to include in the acceptance letter. The reality is, if it's a hostile work environment claim, you don't need to explicitly identify every single allegation. And that can all be addressed in the investigation and with evidence. That said, I think a lot of complainants like to have it listed. I think it helps them feel heard. And I don't think there's any issue with listing out, 10 to 15 times that they identified that they believed they were harassed. But I think a lot of that is a judgment call. If they're listing out 50 things, then it's just too burdensome and difficult. So I think that's really up to the person to make a judgment call when they're drafting the acceptance letter.
Wendy, anything you'd like to add to that?
Yeah, and I have this come up quite a bit actually, and I think taking off on Jacob's point, complainants like to itemize every single event that supports a claim of harassment or hostile work environment. I also find that agencies like it too, because they want to know what they're defending against. They want to know each and every instance of bad conduct that the complainant's alleging that they have to prepare to meet either in a motion for summary judgment or at the hearing. So I think there's a proclivity on both sides to want to itemize each and every incident that the complainant alleges is discriminatory. Now that can be daunting. I just had a hearing recently with a case that had 88 allegations or 89 allegations. The way that can be dealt with in the investigative phase, and the way I deal with it at the summary judgment and hearing phases, is I group allegations of like conduct. For instance, if there's different allegations of offensive comments that are made, I'll have a section that deals with comments. And that may be, 30 of the 80 allegations. If there are allegations of the kind of office environment type of situation, well, I was being ostracized, I got dirty looks, I wasn't invited to meetings, that kind of stuff, then I group those kind of allegations together. So you might not necessarily need to deal in depth with each and every instance of that kind of conduct. But I will say, especially when you're dealing with a harassment or hostile work environment claim, it's incumbent upon the complainant to show that the conduct about which they're complaining was either severe or pervasive. So, and one incident can be severe enough that it meets the definition of harassment, but more likely what you run into it's a pattern of conduct over an expanded period of time that constitutes one unlawful employment practice. Considered together, all of it adds up to harassment or a hostile work environment. So then I need to get a sense of, well, how often was this happening? So I would need information in the report of investigation, which says something like, complainant reports offensive comments that were made by such and such a supervisor on almost a daily or almost a weekly or almost a monthly basis over this period of time. Because if it's an isolated comment that happened, once or twice, that's not going to get it done. But that's important too. I mean, it's not the investigator's job to prove the complainant's case. It's the investigator's job to develop information to be able to allow a fact finder to decide, did discrimination occur? So if the information doesn't, you do the best investigation you can do. If the information doesn't support the complaint, c'est la vie. If you do the best investigation and the information tends to support the complaint, c'est la vie. You've done your job. So we need to be able to get into the granular details enough to know how often did this kind of conduct occur? Is it severe, pervasive? Does it make the standard? And when you're dealing with lots and lots and lots of allegations, think about what are the similarities in some of these allegations and maybe deal with them as a group rather than each and every instance of, he told me I was a schmuck or whatever.
Nancy, anything you'd like to add?
Yes, one thing is to remember, a lot of these allegations, people say things like everybody knows, or, everyone was there in the conference room. Try to get them to give you a couple of specific names and, follow up with them. We know everything's time limited and you always have more work than you can finish. But if you can ask some of the people that complainants identified as having observed this, that's very helpful, whatever they say. Oh, I think you're on mute, Chris.
Sorry, thank you. A follow-up question from the audience. Do you think there's been any major ground on allegations of so-called microaggressions and unconscious bias? Go ahead with that if you wouldn't mind, Nancy.
I'm not exactly sure what the question is, but whether we've progressed in that direction.
I think so.
I think it can be a part of information that we would hear at a hearing if people that, like, I've observed some things where, for example, let's use gender, and where men will say things about, women are silly, women can't follow through. I mean, those aren't too micro, but they're a little bit micro. But you have to have something that adds up. And I think that's the problem with the microaggressions, is a lot of times nobody even knows that they're doing it. So that it makes it very hard to prove that someone, discriminated on purpose. It's one of those things where I actually think some training might be helpful. And after 30 years, I'm not that big on training in a lot of ways, but I think that's something where we don't realize, like, oh, I have an assumption, that Asian people are good at math, or, whatever some of these assumptions are, and people can discuss. Now, why is that a microaggression to certain people? And I also think it's not everybody identifies the same things as these aggressions.
Jake, would you like to add to that?
Sure. So, yeah, I think from an evidentiary perspective, it doesn't come up at the hearing. It's hard to present evidence on that. At the same time, I think, you know, the discussion about this in the news, in research, has been incredibly important for me, and I assume other judges, and just awareness of it, and understanding, having a better understanding of why people interact and act the way they do around others. So, you know, for example, if a couple people go out to lunch regularly, and, you know, maybe they didn't intentionally exclude someone, but they just didn't think that person would be interested, or whatever kind of microaggression or, you know, unconscious biases they have, just having us having a better understanding of how that can impact things in the office and their interactions is useful. But, you know, we don't tend to have expert witnesses about these sorts of topics, and it's incredibly difficult to present evidence or testimony on this sort of thing. So it doesn't have a concrete impact on the hearings, but does impact my interpretation of things.
Andy, anything you want to add?
Yeah, a couple things. First of all, totally agree with Nancy's point about those types of issues revolving around microaggressions where somebody's engaging behavior in which they're not necessarily aware or conscious. In a case of intentional discrimination, disparate treatment, good luck. That's not going to get it across the line for a complainant. That's going to be very, very hard. Obviously, once the person is made aware of this behavior, then maybe that would be a different situation. I think basing a case on microaggressions or evidence of microaggressions being key in a case, possibly in a disparate impact case, which doesn't require proof of intent, but it would have to be something more, I would think it would tend to be something more along the lines of a class case where managers or an agency were acting in a particular way that although possibly looks neutral on its face to many people, has a disparate impact on one group or another. Now, the other problem, in addition to microaggressions being difficult to prove or show intentional discrimination, we were talking a minute ago about harassment and hostile work environment. Now, in a harassment or hostile work environment case, you have to show that the conduct was not just subjectively offensive to the complainant, who's the alleged victim of discrimination, but that a reasonable person in their position would be offended as well. Well, what the heck is that? I mean, you can drive a truck through what's a reasonable person. That's really hard. So I think it's important. I think this is an instance where the law has not caught up with the sociological information. And this undoubtedly will be an area where hopefully the law develops. But right now, I'm not sure, except maybe in the disparate impact style case, I'm not sure that type of evidence is going to make the difference in a case where you have to show intent. So.
I think this question might, from the audience, might help to bring some clarity to that. Can the agency require an investigator to go back to management for more and better answers? So in the idea of, you know, a microaggression, can we find additional evidence, and can they be required to do that? The agent require the investigator to do that?
I would say yes. And not only that, but I can make the agency and the investigator go back and do that if I think it's relevant or pertinent or important. So yes.
Excellent. Okay, let's move on. Let's talk about courts have defined similarly situated in different ways. Talk about your thought process when determining who can be considered similarly situated and how the court ensures it is comparing apples to apples. What guidance can you offer investigators when dealing with comparators in their investigative reports? Let's go to Jake.
I think my best answer would be to use common sense. I think the complainants will often identify people they believe are comparators, and I would use that as a starting point. Though many of the people they identify might not actually be comparators, and that's where you can make your own independent assessment. But it's also not the complainant's responsibility to identify the comparators. And I think the investigators should do a little digging, speaking to in their interviews, trying to determine who else might have been a comparator. And the law, some cases are very limiting as to who counts as a comparator, and other court cases are a lot more flexible. And so I tend to just use common sense. Are they reasonably similarly situated? And that's not a great answer to just use your good judgment, but I think it's the best one I can offer.
Nancy, what about you?
I agree a lot with Jake that it's a matter of common sense. And there are some cases that say you have to have the same supervisor, the same shift, this kind of stuff. I tend to shy away from that because, for example, if you have a hospital and you have a whole bunch of nurses on different shifts, but they're like, say, all doing the same emergency work or something, then you can look at it and use your common sense and say, are these people really doing the same kind of job? Should they be treated the same? And that's where I think the investigators' knowledge, excuse me, of the agency is really crucial, because we don't always know, like at the Bureau of Reclamation, what the heck do they do? Something about dams. So you need to be able to describe the job and explain why they're similar or not similar. And that's, it is really a lot of sort of your common sense, and you're balancing all the issues.
Andy, what about you?
I recognize that the case law is not terribly helpful. It's kind of all over the map. There are some cases that say they have to be the same in every particular, same supervisor, same job, same grade level, same shift, same subject to the same personnel policies and so forth. But there are other cases that say, yeah, but if there are compelling reasons to waiver from that standard, you can do that. So I subscribe to the common sense standard that Jacob and Nancy subscribe to as well. I mean, especially if you're dealing with, let's say the complainant is someone in management and there aren't any comparators. There's no one that holds their job, they're it. So you have to look for like peers in the organization that are as close or similar to what that person does. Because not everybody, is in a job that there are a ton of at the agency. Occasionally you get a complainant that is kind of in a unique situation. So you can't apply that standard to that person. So you have to use your common sense.
Got it. Okay, let's move to a question from the floor. What percentage of cases result in the finding of discrimination? Andy, you want to start with that as a guess?
The quick answer is I have no idea. The second answer would be the minority of cases, certainly. I think most cases, there are cases that are dismissed for jurisdictional reasons. They're brought too late, they're not timely, or they fail to state a claim, or they state a claim that was resolved in an earlier proceeding. So those cases have jurisdictional defects. There are cases where the complainant just can't, they have a feeling or a speculation or a sense that they're being discriminated against, but they don't have the facts or the information to make a prima facie case or overcome the pretext burden. And there are cases that just have no merit. There is no discrimination. Frequently complainants think they know what happened, especially when we're talking about comparators. Well, my fellow in the cubicle next to me, he got to take leave anytime he wanted it, or he wasn't disciplined for the same thing I did, and they actually don't know what happened with that person. So, but then there are meritorious claims that will go to hearing or will get settled out. I don't have the ready statistics what percentage of cases have merit and those that don't.
Jake or Nancy, would you like to add anything to that?
Sure. Sorry, were you going to go, Nancy?
No, go ahead.
Okay, so I've heard different numbers thrown out, and they are exceptionally small, and I also think they're misleading. You know, I've heard something, you know, like 1 to 2% of cases and result in a finding of discrimination for a complainant. And the reason why I think that's misleading is because I have 10 to 15 cases a year that result in settlements of above $40,000, often above $100,000 or $150,000. And those are not findings of discrimination for a complainant, but I think they are a winning result to some extent and a substantial remedy for the complainant. But those wouldn't be included in that 1 to 2%. The other factor is that just because they can't prove that they were discriminated against doesn't mean it didn't happen. It's a very difficult thing to prove intent in this process. And so I think there are a number of cases where there may have been discrimination and they just can't prove it. And then, like Andy mentioned, there's also a lot of cases where it just wasn't discrimination at all. You know, they may have been treated unfairly, but there's no evidence suggesting it was because of their race, sex, disability, whatever it might be.
Nancy, let's go with this question from the floor. How do you handle cases where there was clearly harassment or targeting of an employee, but the complainant did not make a case for connecting it to an EEO basis?
Well, that complainant, unfortunately, if you can't connect it to an EEO basis, you lose. And I spend a lot of time explaining to people, I can't make the world fair. All I can do is ensure that people don't harass you because of, you know, race, religion, gender, disability, age, national origin. I think I hit them all. And so people are usually shocked by that. And I say, you know, the MSPB can help you if you have a discrete action, like you were denied an award or you were not promoted or something. But I have a very limited jurisdiction, and I tell them from the initial conference, you have to connect it to any of these bases or else you just lose.
Okay, so let's go to wrapping up. And here's my question. What do you want an investigator to never forget when submitting an ROI? Nancy, we'll start with you, and let's keep it to a couple of sentences so we can end on time.
Never forget that you're neutral, but also never forget that you need to get as much information that's out there that goes to the elements of the claim.
I like that. Jake?
This is repetitive of what we said, but I want to repeat it. I think it's important. Please ask follow-up questions. When you get an answer that is either not responsive or unclear, get it clarified. Put them on the spot, make them answer the questions.
Thank you. And Andy?
There's no such thing as too much relevant information.
It doesn't get any simpler than that, does it?
and the investigators are trained to know what's relevant. And we have to trust the investigators. There's no such thing as too much relevant information.
I want to thank all of the judges for taking their time out of their busy schedules to be with us. Andrew Winston, Jacob Smiles, and Nancy Weeks, thank you so very much. And finally, I just want to remind everybody that coming in May 2021, there's the 2021 annual EEO refresher training, which is online. And in 2021, also a 32-hour new investigator training. And then in June, Working Smarter, Not Harder, productivity tools every EEO investigator should know about, and that's a webinar. Thank you all for being here. Judges, thanks for your insights. Investigators, thanks for taking the time to be with us, and we look forward to seeing you at our next webinar or online at a training. Thank you, and take care.